All right. Well, we'll get started. My name is Lisa Graves, and I am so excited to welcome you to this webinar, this panel discussion about the Voting Rights Act and the threats that this fundamental, vital landmark legislation is facing from the U.S. Supreme Court. I'll introduce myself in a moment, but let me turn this over to my fellow presenters, and I will start with Spencer Overton, and then we'll pass it over to you, Evan, and then back to me.
Hey, thanks so much. I appreciate it. It's great to be here. My name's Spencer Overton. I'm the Patricia Roberts Harris Research Professor at GW Law School. I'm also the Faculty Director of the GW Multiracial Democracy Project.
And good afternoon, everyone. My name is Evan Milligan. I'm co-director of the Sanctuary at Jubilee Community Center, a community arts center based in Montgomery, Alabama. I'm also a senior fellow with the Western State Center, and I'm the named plaintiff in Allen v. Milligan, a little voting rights case that I'm sure we'll talk a little bit about today. It's nice to see everyone.
Thank you, Evan and Spencer. Again, my name is Lisa Graves, and I am the co-founder of Court Accountability, and I also lead True North Research, which is a watchdog group. And I am the author of a new book about John Roberts and the Supreme Court called Without Precedent, which touches on the Voting Rights Act. But that's not the point of this call. The point of this call is to talk about the case that the U.S. Supreme Court is considering right now, that the Roberts Court is considering. Some of you may have covered or followed closely the oral arguments in that case this past month, earlier this year. And we are obviously awaiting a decision in that case. But this is no ordinary case. This is a ruling that could dramatically not just rewrite the maps in America, but change what it means to have real representation in our Congress and in our state legislatures and other elected bodies. And so I have a lot of views about that, but I'm gonna start by turning it over to my colleagues here to share their perspectives on what's your view of this case. I don't want to necessarily get into like how it's going to come down yet or that speculation, but what are the stakes as you see them? And I'll start with you, Evan, if that's all right.
Sure. Well, I think the Calais case, and the reason that we're even having this conversation is we're all concerned about the impact that and the door that it will open to undermine voting rights protection here in this country. And I think for me, it hits a personal chord because the plaintiffs in that case, some of them are friends and colleagues. We were all doing redistricting outreach and work in our respective states, them in Louisiana, and then my co-plaintiffs and I here in Alabama in 2021. And that work that we were doing sort of positioned us to serve as plaintiffs in our respective cases. And our cases are almost identical as far as the facts that are emerging. It just so happens that ours was chosen for oral argument first. And because of the decision in our case and the court, agreeing to at least temporarily uphold Section 2 of the Voting Rights Act, that had a positive outcome for these Louisiana plaintiffs. And then as the politics have changed due to election outcomes in Louisiana, that leads to the events where the case is now being reconsidered. And we're sort of on pins and needles waiting to see what will happen. And I think I don't need to sell the significance of the VRA to this panel or this audience, but as a person that's been working in the nonprofit sector for most of my life, I know that for many of us, when we try to point to the impact of our work and why it's worth investment and things of that nature, it's hard to find something that has as much of a before and after paradigm as the 1965 Voting Rights Act. And I know that Spencer is much more well versed in those statistics as well as you are, Lisa. But losing that would be a tremendous step back for our country.
Yeah, I really agree with Evan. And to just put it into context, right now, the Voting Rights Act, Section 2, is really the only break on excessive and massive gerrymandering. A few years ago in Common Cause versus Rucho, the court said We're not going to police partisan gerrymandering. We're not going to get into that. They can do that as much as they want to. And so, as a result, Section 2 of the Voting Rights Act has been really one of the few breaks on massive gerrymandering. And what I'm talking about is this, Lisa and Evan, as you all know. Right now, we talk about one person, one vote, and that sounds great. The problem is that one person's vote weighs a lot more than another person's vote just because of the way politicians draw lines. Right now, the Voting Rights Act is the only thing that prevents politicians from just slicing and dicing and dividing communities of interest into different areas and diluting the opportunities of Latinos and Asian Americans and Black folks and Native Americans to elect a candidate of their choice here, right? It's the only break, and that affects everybody. As you see right now, there is a massive race to basically stop the electorate from preventing a trifecta, a continued trifecta by the Republican Party. And that massive race is dismantling existing districts and basically saying, hey, we can ignore the Voting Rights Act because we don't believe this court is going to enforce it. And so we can dismantle districts in North Carolina and Texas where voters of color can elect candidates of their choice. And so they're doing that for power, political power here, right? But it obviously has some real racial implications. And I'm sorry, I just do want to finish on this. Some people say, well, hey, they're doing it for political reasons, they're not doing it for racial reasons. But Evan, from Alabama, when they said people in Selma couldn't register to vote in 1965, it wasn't just because of racial discrimination. It was they were afraid Black people were going to vote to dismantle segregation. They were afraid of the political implications of that. There was a political reason. So those things were intertwined here in terms of race and politics here as they are in this situation. And so we could lose 12 to 19 congressional districts where voters of color have an opportunity to elect candidates of their choice. But that's just the tip of the iceberg. And we're all paying attention to that because we're paying attention to the horse race of who controls Congress and will this trifecta continue. But the real thing that's at stake, I mean, there are only about 537 federally elected candidates here who, in the country, offices, right? We got 600 races or 600 offices, 600,000 offices across the country total, right? So that's state and local, school board, city council, county commission, state legislature, public commissioner, etc. All of those places are subject to the Voting Rights Act as well. And many of those districts could be dismantled if we get a bad decision in this Calais case.
Evan, do you want to jump in, or shall I go forward?
Oh, please. Uh,
Well,
no, oh,
I really appreciate that grounding from both of you, and just wanted to add in when we've been looking at this case at court accountability, we see this case, the fact that the Supreme Court has taken up the Calais case, even in the first instance, as a sign of this pattern that we've seen from this Supreme Court, this Roberts Court, which is that the John Roberts and his fellow Republican appointees have been on a partisan basis in party line votes, dismantling key components that protect the integrity of our democratic process. There's a sort of trifecta of areas. One is the Citizens United decision, which unleashed this massive amount of money into our elections, giving billionaires extraordinary power over our elections, including the presidential race, but also congressional races and more. The second was the Shelby County case in 2013, where John Roberts used his pen as an axe to cut down Section 4 and Section 5 of the Voting Rights Act, which required pre-clearance before states and jurisdictions that had a history of discrimination, of suppression of the vote, of trying to make it harder for Black Americans to vote and to dilute the effect of their votes, to have any changes to where the polling places are, when the polling places are, all manner of those changes to be pre-cleared because Congress knew and had seen a pattern that it made findings about in the findings supporting the Voting Rights Act of all these different ways in which legislatures would use different mechanisms to try to minimize the Black vote, if not stop it as well. The third part of that trifecta of cases was the Rucho case that Spencer mentioned, which was the first in an effort by this court to assert that the court was not going to intervene even in extreme cases of partisan gerrymandering, but it said in that case that it would still prevent racial gerrymandering. And yet, in the subsequent cases that followed that, Brnovich and then the Alexander case coming out of South Carolina, just in essence, months and months ago, but a few months ago, we saw this court, in an opinion written by Samuel Alito, signed on again by this partisan Republican appointed majority on the court, saying that South Carolina could bleach out 20,000 Black voters in the first district of South Carolina. And even though the lower courts found that that was a racial gerrymander, Alito and Roberts and that crew said that as long as they were acting for partisan purposes, they would allow that. And so what's happening right now in the Callais case is, in my view, an effort to bleach out not just the first district of South Carolina, to bleach out the representation in southern states of Black members of Congress, as well as the implications for other minority majority districts across the country. And this isn't happening in a vacuum. This is happening in the very time in which Donald Trump is demanding that state legislatures rewrite their maps to prevent there from being accountability for his policies and the policies adopted, embraced by members of his party in Congress, in order to prevent there from being investigations, impeachment, or other ways to have a restraint on this president. And while he's urging Texas and other states to rewrite their maps, and some of them are, as we've seen, the Roberts Court, is poised to help Trump try to pre-rig the 2026 midterm elections by unleashing another wave of map drawing in order to have that effect, in order to block the power under Section 2 of the Voting Rights Act for there to be minority majority districts and to prevent the dilution of the vote of Black Americans. The threat to our democracy, in my view, could not be more grave. And I think we have to understand that what's happening is not just some sort of swing in the pendulum. If this court, the Roberts Court, were to rule in the way that some are predicting, what they would be doing is saying that Congress cannot protect against vote dilution through having Black majority districts, that it cannot. And what we've seen in the Callais case, and then I'll turn it over to you, Evan, if that's all right. What we've seen in the Callais case is a situation where in that legislature, in that southern state, in Louisiana, more than 30% of the population of Louisiana is Black. But when the white majority legislature drew the maps the first time, they allowed 5 white majority districts and 1 Black majority district. And only by court order were they required to add that second district, which of course is the district that's being targeted here. And that's not all. If this court were behaving like a normal court, it would rest on that Milligan case, the Alabama versus Milligan case that Evan was a lead party to, because that's a recent decision where the court already affirmed that the Voting Rights Act is still good law. And yet, in the Supreme Court's oral arguments, we had Kavanaugh and other justices assert, maybe it's been too long. Maybe we need to get rid of this Section 2 of the Voting Rights Act. Maybe we can't have a racially conscious remedy for the structural racism, for the discrimination in the voting. And that suggestion is also one that shows the illness that is plaguing this court, because it is not the role of the Supreme Court to be the fact finder on the Voting Rights Act. Congress was the fact finder, and it extended the Voting Rights Act for until 2030 based on detailed factual findings that John Roberts already once disregarded. And so I would say to you that if this court destroys or crushes the Voting Rights Act Section 2, that will be an illegitimate act by this court. That's my view. Evan, do you have thoughts?
I do. I think I would also maybe build on that last statement you made, the illegitimacy, because looking at the impact of the Voting Rights Act, the fact that there were, I believe, about 70 Black elected officials in the Deep South pre-VRA in the early to mid 60s, and then by 1966, or at least by the mid 70s, that number had risen to 5,000. So if we're entering a period of time where, as you say, there's an illegitimate decision that undermines that growth, I- the the broader sort of implications are what worry me the most, because Black communities are not just going to sit idly and allow themselves to be treated as second class citizens, or whatever the term is. There's going to be some type of organizing and mobilization. There's too much information available. We've lived in this paradigm of the VRA for 6 decades now. So there's the sort of spoils of that policy are ingrained in things that all of us take for granted. And once we're revisiting that, I would assume that the people who feel the most, that there's the most to gain from moving in that direction, that there are some other things that they would do to to undermine the organizing capacity of now these millions of African Americans who would be discontented by the move in this direction. And I can't imagine that there wouldn't be a wave of other policies that would impact freedom of speech and all of our civil liberties, all of our constitutional rights, that would spread far beyond the African American community. And so, the tip of the iceberg is preventing people to access the ballots that choose who those decision makers will be and what acts of government they will actually hold accountable to some sort of constitutional standard. And if we're moving into an era where illegitimacy and really the rule of law is whatever the party that's in power is declaring it to be, that's excessively dangerous.
What do you think, Spencer?
So I want to provide a little bit of context here in terms of where we are. So we talk a lot about 1965, the Voting Rights Act, incredibly important, right? 2 months after the Voting Rights Act, the Immigration and Nationality Act passed. And really, these two laws transformed our nation. And the reason that's important is because in 1960, about 15% of our population was people of color because we had discriminatory immigration laws. And the Immigration and Nationality Act really reduced discrimination, racial discrimination in immigration, much as the Voting Rights Act reduced racial discrimination in terms of election systems here. And as a result, now we're over 40% people of color. Back then in 1960, the U.S. House was less than like 3% people of color. Now it's like 28%, right? And so we kind of got this cultural anxiety that is happening in terms of our nation and this kind of political backlash in the political sphere. And really, unfortunately, the Supreme Court is kind of complicit in that in this moment in terms of trying to allow incumbent powers, really kind of a gerrymandered population that really restricted to immigration to people from Europe for a long time in terms of excessive bias there. And trying to hold on to that by chipping away at the Voting Rights Act. Now, we talk about this political institution. When I sat in that courtroom in Calais, I was concerned about the Voting Rights Act. I was also concerned, is this a political institution that's equipped to deal with the challenges of a multiracial democracy? Like their biggest fear was, are we stereotyping black voters? They didn't even mention are voters of color, do they have an opportunity to elect candidates of their choice? Like, are they being represented? That wasn't on their radar screen. This notion of a presumption, you talked about that South Carolina case, and not only did they say this is politics rather than race, they said we're going to presume that legislatures are acting for political rather than racial reasons. So they put a finger on the scale. For them, it is more, or for some of them, it is more offensive to be suspected of racial discrimination than to be discriminated against based on race here, right? And so I just do think there's this question about the institution. And then finally, you talked about Shelby County. There was this precursor to Shelby County called Namudno. We kind of dodged the bullet Namudno in 2009. 2013, Shelby County happens, and Section 5 is effectively scaled back as a result of the coverage formula that you mentioned. I guess my concern is that Evans' case in terms of Allen v. Milligan, the question is that our Namudno, or will the court faithfully just be a real court in terms of following the law and follow Allen v. Milligan?
Right. That's what should happen. The court should follow Allen v. Milligan and should not inject itself in trying to further this extreme districting that has these enormous consequences for representation. The right to vote is, in essence, a gateway vote to other rights, to securing other rights. Did you want to jump in, Spencer, and then I'll come
I,
back?
I,
Yeah.
I do want to just say one more thing. I'm sorry that, okay, I'll just be frank, Voting Rights Act does not require proportional representation, right? But in in Alabama, black folks were about 26, 27% of the population, but they only could elect 13% of the congressional delegation. There was a Voting Rights Act violation found that was moved up to about 26%. In Louisiana, black voters are only about a third of the population here. They could only elect one-sixth of the congressional delegation. There was a Voting Rights Act violation found. They could elect like, a third of it. So just in terms of basic fairness, and again, I know the Voting Rights Act does not require proportional representation here, but proportional representation should not be a bad word. The notion of kind of one person, one vote for real in a meaningful way, where your share of votes equals the share of seats that you get in the legislature, that shouldn't be, a bad term. That really should be democracy, and it really is in a lot of places in the world.
No, I think that's totally right. And I just want to add this question on um, you know, is it political? Is it race? This was an interesting piece when I was working on my book, and I looked into, how did Roberts get so involved in trying to assail amendments to the Voting Rights Act in the early 1980s during the Reagan administration? And it turns out that he had clerked for Bill Rehnquist. People knew that. Rehnquist was a very regressive appointment to the court, and he had spent time in Arizona trying to make it harder for blacks to vote in Arizona, trying to suppress the vote. He was part of an operation called Operation Eagle Eye, where he himself and others would go to polling places in black neighborhoods outside of Phoenix, in Bethune, for example, and photograph voters to try to intimidate them. When he was confronted about this, he said he wasn't trying to intimidate black voters, he was trying to intimidate Democrats. And then we
Hmm.
see that come full circle in that case out of South Carolina, the Alexander case. But it's not just that. When Roberts was clerking for Bill Rehnquist, Congress was busy trying to undo a decision that Rehnquist helped join to limit the power of this section, Section 2 of the Voting Rights Act, in the Mobile, Alabama case. And as Roberts was clerking for Rehnquist, Congress was across the street trying to undo the damage done of saying you had to prove racial intent versus the effect of a change in the rules that could dilute the black vote in America because of the real history that we've seen. And then what happened next was that Rehnquist called Ken Starr to ask him to get John Roberts a job at the top of the Justice Department as a special assistant to the Attorney General. And then he was made the point person, assailing congressional efforts to overturn that Supreme Court decision. That's where he cut his teeth. And then the first real chance he had in that Shelby County case, he used the power of the court to cut down a crucial enforcement provision. And now here we are in 2024, 2025, with John Roberts poised again to use the power of the court to decimate this vital provision, and not just decimate it from a statutory interpretation standpoint, but perhaps to claim that Congress has no power to redress this, claiming that it's unconstitutional to protect against this kind of dilution of the black vote, when the purpose is really dilution of the black vote and combined with the politics, not two separate things where you can separate it out, as both Evan and Spencer have described. They cannot be separated out. And so, what I think of this as fundamentally a destructive act by this court, if this court goes forward in doing so, and not merely a swinging of the pendulum, not merely, oh, you lost in
Mm,
the appointment process, because this court was also constructed in a way that no court has ever been constructed in US history, where people
mm,
were specifically chosen
mm,
to try to reverse the law, to not be
mm,
suitors, to be no more suitors. And John Roberts was the first beneficiary of that. And his agenda on voting rights and democracy, I think, has been one of the most destructive components of his tenure on the court and the tenure of the Roberts Court. So thanks for letting me share that little
mm,
historical
mm.
dive.
There's a question in the chat about how would a constitutional right to vote, so thinking about, having a 28th or 29th Amendment to the U.S. Constitution that explicitly declares the right of U.S. citizens of voting age to vote and have their vote counted. And I think that, for me personally, I think that is one of the tactics that we should center in our pro-democracy movement, along with passage of the Freedom to Vote Act, the Fair Representation Act, the John Lewis Voting Rights Advancement Act, and then state level analogs to those federal policies and the federal constitutional amendment. The problem is, and the question that I have for you is, when you look at our voting rights and just our broader American culture, the landscape of organizing, and then you think about the amount of work that's necessary to even get John Lewis passed, because that at least made it out of the House and then died in the Senate a few years ago. But the burden to get a constitutional amendment passed is so much higher. We've only had 27 of them. Um, the intense amount of coordination and organizing within our fragmented media landscape, what it's more than a notion. And so believing that that's the right approach is one thing. Making it happen year by year incrementally is another. Do you have thoughts on what we would need to do to get there?
So let me respond to you, Evan. And I agree with the concept of a constitutional right to vote. My concern, though, is with this court, they would construe it so narrowly and defer to local election officials or discriminators so much. So, for example, due process, takings clause, there's arguably a right to property, right? But
Right,
obviously, property can be regulated, right?
right.
And similarly, here, this court would likely allow for, even if you had a constitutional right to vote, excessive regulation so
Mm,
we do all that work for a constitutional amendment, and because the court itself is so flawed, I think we'd end up with some bad results here, right? And so there's this concept of maybe we need to rethink this court in terms of how it's structured, and does it function to serve the diverse and large democracy we are? Is it right now kind of more of a political institution? Or is it really truly a legal institution that fairly serves all? And so I think that is kind of a statutory question that we could consider and deal with. So that's kind of one bucket. There's another bucket here, is that ensures one person, one vote. Right now, we arguably have one person, one vote. There's an equal number of votes in each district. The problem is that they draw lines in ways that make some votes more important than others. They make some votes district safe. They pack us into certain districts so we don't have influence in other districts in terms of folks of color. And so even though there's this formal one person, one vote, it's not kind of meaningful. And I know that, I know I'm an academic and I'm a dreamer, but I really have to go back to a mentor of mine who was not confirmed for her ideas, and her name was Lonnie Guinier. And
Hmm.
she basically saw this
Hmm.
coming. She basically realized this court, after Shaw v. Reno, was going to go
Wow.
down a colorblind path, and that districts were not necessarily the way to do things, and that a group of votes should have an equal share of seats in the legislature. And she encouraged us to consider proportional
Portion.
representation, which
Right.
is done in various, countries around the world, and where it's very difficult or even impossible to gerrymander lines. And what that does is it doesn't even just help Black folks. If you look at the congressional delegation in New England,
Hmm.
even though about a third of New England, more than a third of New England is Republican, there are no congressional members from New England who are Republican because of gerrymandering, and there's not proportional representation. So systems like that would ensure that everyone is heard based on how they vote together. Unfortunately, that kind of thing doesn't allow kind of the current trifecta to manipulate lines to kind of hang on to power. And I'm not pushing back against you, Lisa, but you know, this manipulation is happening not, it's happening to prevent voters from
Right.
disciplining the incumbents. It's not happening just to prevent Democrats from winning. This isn't a partisan thing. This is about silencing the country and voters and preventing voters from holding elected officials accountable and changing the rules to do that, right? And that is really what's going on here. And frankly, if the Supreme Court makes a bad decision here, it's complicit in that.
No, and I
Lisa,
agree. I think it's both, is to be fair. I think there's both a heavy partisan component right now in this moment in terms of Trump's desire, and it is also it is part of a larger systemic problem of all the ways, including big money, that has really
I,
minimized our vote,
I
our voice.
totally agree with you. I think the reason that I really want to nail on this is because some people say, oh, that's just Democrats and
Yeah.
Republicans and just fighting it out. It's just political stuff. I can just ignore it because both sides are bad, etc. And no, that's not what's happening. What's happening is incumbent, powerful people are preventing, and again, I know that there's a political element to it, obviously, but there's also a democratic element to it in terms of,
All
can
the
voters discipline and hold entrenched power accountable, or will those folks entrench their power further, not by being more responsive to voters, but by manipulating the rules? And that's what we're seeing.
Yeah, and I definitely see that, and I'm going to stand back ask you, Evan, to respond as well. So then I'll
well,
come back to you.
there was a follow-up. I just wanted to make sure y'all saw it from Diane Russell who asked the initial question. She followed up and said, yes, even if it was a long slog to get a constitutional amendment passed, wouldn't we want to be setting the narrative accordingly? And that when I would try to sell this strategy or persuade colleagues to consider it more in the organizing world, that was sort of my fixation was where is the emotional thread for all of the folks who look at our two-party system and may look at Congress and whatever representation they see, because of narrative, because of misinformation, because of personal experiences, they don't feel like it's an institution worth saving. They don't feel like the voting process and the election booth is symbolic. You know, it's not a pathway to liberation for them. It's not a pathway to a better day. It's something that feels imposed or whatever. So, what is the thing that animates people to consider something that takes a long, multi-decade struggle to achieve if it's not something that they personally feel investment in? And I think that's where narrative work and cultural work is really, really, really important. And we've tried to play with that and explore experiment with that in the Shake the Field work, as well as the work with Western State Center in terms of exploring popular education styles of putting these ideas and terms in music and in lyric and things that folks who don't have law degrees or PhDs can relate to on an emotional level. And there's so much there's like the hill that we have to climb there and the resources that will take. I feel like we're so far at the very beginning, even though celebration of the civil rights movement is also a part of our culture. So we lionize the era that figured out the connection between culture and popular education and policy advocacy, while you know we have so far to go to use those strategies for this current moment.
So I want to basically echo. I agree with Evan, and I want to build on it in terms of sometimes as lawyers, we think this is just the right policy and plumbing, etc. But I just really think we can't ignore culture. Culture is key here. You know, if you think about Germany here and kind of their
Mm,
remembrance culture, and that's a part of their national identity in terms of remembrance culture. And that's unfortunately not a part of our culture here in the United States. And so, you know, in terms of the repeal of certain books from the Naval Library and cutbacks at the Smithsonian in terms of the Blacksonian Museum, like there are some folks who appreciate the importance of culture, and I think we have to also appreciate the importance of culture. And certainly the right to vote can be center and narrative, I would agree with you, is important. But I also want to come back to this. And goes to Darcy's point here, like how would we, if we pass these great reforms here, how
mm,
would we protect them from the interference from the voting rights, from the Roberts Court, right? And I think that there's two pieces. One is, I do think it's going to be hard for them to deal with proportional representation from a constitutional standpoint. It's race neutral. And so I think it's safer than what we have now, at least from them and the logic that they've used in the past. But the second piece is we can't afford this is the elephant in the room. We can't ignore this court and pretend like it doesn't exist and not hold it accountable here. Because it's this in terms of the Voting Rights Act, but it's also Citizens United. There's so many areas of the law. It's being a president, knowing you have immunity and feeling like you can just do anything to anybody and use our tax dollars to target people or whatever, and knowing that you're going to be immune. There's so many issues in terms of this court that we have to face it squarely, as opposed to saying, well, let's just enact this legislative policy or come up with this constitutional amendment to deal with this stuff. There's a source of some of these problems, and I think we got to be honest about it and face it and figure out what a real solution is in terms of this court.
Yeah, I agree with all of that. And the fact is that the court, everything is going through the court. If we do not contend with how out of control this court is, it will continue to reverse and erode our rights until we stop it, until we reform it. And, to Diane's question of the long-term strategy, yeah, No good legislation can pass this Congress to reform this court. Not happening. But that doesn't mean that we can't be and shouldn't be using our powers, our efforts this year, next year, the year after to build that case for why court reform is an essential part of getting the substantive reforms we need, of changing the policy. I used to have arguments with people about Citizens United that went something like, well, we've got to do something about campaign finance reform. And I would say, you mean corruption? You mean corruption? Because talking about campaign finance reform means nothing. No one's going to go march in the street for campaign finance reform. But if you're like, look, this system has these core elements of corruption, and that's preventing us from having policies that help our families thrive. And so we need to come together and say, yes, and yes, we need to reform this substantive. We need these substantive changes to make our lives better, to help our families do well, to help our communities thrive. And if we don't add court reform or these structural reforms to that, we cannot prevail. And so we have to have a long-term approach, and we have to have a broad approach that dreams big and thinks big about what's possible. And then, as you pointed out, Spencer, there are a number of measures that could be statutorily passed to rebuke this court, to limit its excessive claims of power, its aggrandizement, the judicial supremacy that we're all witnessing, and try to restore a proper balance where we, the people, through our representatives and having representatives who really do represent us in the broadest sense versus this partisan gerrymandering and the racial component of it that is, manifest in the opposition to the Calais, in the Calais case. If we actually have that, we could have a better democracy, a better functioning democracy that delivers. But none of that can happen, in these abstract legal arguments, as you say. And, a lot of people have been talking about since the 2024 election that politics is downstream of culture. And so we have to be thinking about how all of this affects our lives and the way art and music and action can help people to have that sense of hope. Because this sort of authoritarian posture by this court and by this president, and it's not all partisan, but the current circumstance we face of this unity between this court that has given Trump immunity, unprecedented immunity, and then followed that up with 24 decisions on the shadow docket to take down lower court orders trying to protect our rights, protect immigrants' rights, protect citizens' rights, protect our money that Congress has allocated to go to the things that help support us. This court has been acting in tandem in a way with this president to move this authoritarianism forward in America, really for the first time ever. We've never had a president who had this sort of broad grant of immunity, and the consequences for all of us are enormous, which makes it hard to organize. But I'm really heartened by the no King's marches, and more by the number of independents, people who were, former Republicans, even former Federalist Society members and leaders who have been standing up and saying, this is not the America that we've been promised. This scenario does not fit our ideals, and we have to protect our democracy and our people so that we can have our Constitution actually be, serve the ideals that it says it stands for, and improve upon them for we the people, for our general welfare. So I do think this is a long-term battle, and that's one of the reasons I'm so thrilled to have this chance to be on this panel with the two of you, and to be in unity with some of the folks in the audience about the fact that this is a long-term effort, and we need each other to build the momentum that we already have in some ways, but to build that momentum and carry it through to actually restore and expand our rights.
So
Spencer, you
go ahead,
mentioned
Evan.
you mentioned Professor Guinier, and I just wanted to ask a follow-up. I remember that there was this concept she had about the canary in the coal mine.
Mhm.
Is that related to what you're talking about? That she was, saw foreshadowed and saw down the road. How does
Yeah,
that connect?
she and Gerald Torres came up with the concept in terms of canary in the coal mine. And really the concept was, for the least of these in our country, they are the canaries in the coal mine. And this is going to happen to all of us. And so we really have to be concerned, whether it's Latinos or Asian Americans or Black folks. We need to be concerned about their humanity, because what's happening to them now is going to happen to all of us. When Black women, when the unemployment rate for Black women is high, we really need to be concerned about that because that's a marker that a recession is coming for all of us and that, unemployment's going to hit all of us here.
So on that point, I grew up in a household that was Black nationalist, Pan-Africanist, Protestant Christian, humanist, and kind of socialist, right? And so that was a lot to balance. But what so in my organizing, if I'm going around Alabama because of the poverty rate, and coming from a working class, middle class background, I'm around white people who I can relate to. But because of how our media landscape is structured and our social landscape, they are not going to hear this information. They're going to hear commentary on this information that predisposes them to interpret it in a certain way. And one of the things that I've wondered about is, are we in a space that is somewhat unavoidable in order to create new political opportunities? That as bad as this administration is, as demoralizing as all of the illegal things that are happening, if the constituents who are poor, who are white, who are evangelical Christians, if they don't have this opportunity to experience the implosion, which I think that this moment will implode, um, then that there's a it, where is the opportunity for them to
Right.
come in a multi-class, multi-ethnic coalition? Then on the flip side, if it doesn't implode and it actually figures out how to deliver real resources to those constituents while it's stealing and taking them from other members of the American society, then of course that's the worst outcome that all of us are afraid of. And so the canary in the gold in the coal mine and thinking about poverty, um, it's just a thing I've been wrestling with
Right.
my whole life. Yeah.
Yeah. Well, there are a couple things in here that inhere in what you've said that, this has been a long-standing issue and challenge. In the 1800s, we had fusion voting. Basically, white working class folks wouldn't vote in the same party as black folks often.
Mhm.
But if you use fusion voting, people who are in different parties could vote for the same candidate and they could elect a candidate that advanced
Hmm.
their interests, right? And so fusion voting was actually abolished to prevent that, like the Wilmington situation in North Carolina, that government that was dismantled here by force was elected as a result of fusion voting. So this has been with us for a while. And not only has it been with us for a while, but we see it around the world. Like if you think about Alternative for Germany, AfD,
Yeah.
if you think about Brexit in terms of the UK, there is this cultural anxiety, a nativist, a piece that's there. If you look at Germany, the part of Germany, the former East Germany, which is very white, very few immigrants, etc., very few jobs, very few companies, that is the base of the alternative for Germany. AfD is the name of the party. So this is really kind of a worldwide movement. And that's, one of the concerns we have about kind of Musk engaging with these folks and the vice
Right.
president, the fact that all this stuff is connected. So we can't ignore this. We've got to figure out a way without just appeasing people. We got to figure out a way to make a place for everybody here in
Mhm.
terms of our society. And then I think we also have to recognize that there will be a post-Watergate moment. There will be a post-Bloody Sunday moment where you have a space to do
Hmm.
something. And the question is, are we ready? Do we know what is it that we want? Do enough people know that this court is a problem to basically say, okay, well, dealing with the court is one of the priorities we have in this post-Watergate moment. Do enough folks recognize that money in politics is an issue and corruption is an issue so that we can deal with those things? So really preparing people now so that when you have that window, that opportunity, it may not be big, but maybe only 18 months, but you can really make generational change in that time period. And so the big key, we don't know when it's going to come, but being ready when it comes, I think.
I think that's right. And when you look at the polling, one of the things that's interesting is that gap because a substantial majority, when polled, substantial majority of those polled say that Citizens United should be overturned, that it's the wrong decision, that it's been bad for our democracy. A substantial majority have also indicated this court needs some reform. In fact, the court is at its lowest public support basically in history from 2023, 2024 to now, right now compared to years of it being held in high esteem, in part because of the rulings of the court and in part because of the investigations about the corruption that has engulfed the court that people are seeing. So in some ways, what we're seeing is that a lot of people understand that the system is not working properly, that in many ways there are things that are broken, and the court is part of that. But the gap has been we haven't had necessarily leaders in Congress willing to take up those reforms. They've been entrenched in ways that have limited reform. The fact that we were so close to passing that John Lewis Voting Rights Restoration Act, and just a handful, like all the Republicans plus a couple Democrats, were able to stop that,
Right.
and then the procedural rules were allowed to thwart that. Whereas the stakes are so high that the effect of allowing that not to pass is also making this moment possible. But I agree with you, Spencer. We need to be prepared to respond to that post-Watergate moment with a slate of ideas that can really move forward. And I think when you look at some of the polling, and I'm not someone who believes the pollings are all, sacrosanct, but I think there's a lot of discontent and generational discontent as well about our economy, about feeling that the election process is not responding to people's needs, and that makes it hard to motivate people. But I also see a tremendous surge in interest and enthusiasm to stand up to make things better because the system and the situation is so dire for so many people.
Mm.
We
Um,
are at 7 minutes, so I should invite you, Evan and Spencer, to share some closing thoughts so we can wrap at the top of the hour. And also, in doing so, invite you, I hope, to come back and have a continuing conversation about this. The Supreme Court's decision could come as soon as January. That would, if it comes down and in a way that undermines the Voting Rights Act, that could unleash another wave of this map redrawing, or it could be on the June docket and sitting there like a poison pill for the president to use to say he doesn't want to seat people who are elected under this system if the court criticizes it as unconstitutional or unfair. But we've got some weeks and some months ahead to continue this conversation. And I'm just honored to be in dialogue or trialogue, I suppose, with the two of you. So, do either of you have any parting thoughts, and also which of you would like to go first and last in that?
Evan, I'll defer to you. You can go ahead.
Sure.
Mhm.
All right. So, for me, my family is a huge point of motivation and a place where I get hope from. This is a book. It's called My Race to Freedom. It's written by Gwen Patton, who was a SNCC organizer she was a student at Tuskegee, um, and also a co-founder of an organization called Project South. And they have been, really, really critical leaders with development of people's movement assembly infrastructure in the US. And that's been a place that has been helpful for me to practice democracy. And when I look at that space, when I look at workers' cooperatives, when I look at the work that Aditi and her team are doing with Democracy 2076, where they're really trying to, or even the work we're doing with the Common Good program at Western State Center, trying to really bring people who have very different ideologies and interests, but are aligned on the need for freedom, democracy, and protection of the commons, oceans, outer space, democracy, the internet, like these things that we share. And I've never at being in my mid 40s, father now, a husband, having worked as an ED, I was never as aware of my weaknesses and my own frailties and the ways that even I can give in to the voice of my way or nothing until I became a parent and entered marriage and had a chance to be an ED. And I think democracy is something that we have to practice. We have to practice it in our workspaces, in our families, in our social spaces. And there are some very bright spots that I see cultivating more of a healthy respect for daily practice of democracy. And I think as those spaces grow, we'll have such a deeper bench of emerging leaders and organizations that will think about the questions as far as economic rights, campaign finance reform, statutory versus constitutional, and of course, find that emotional thread. So, I hope that those listening will find the groups in their networks that are doing that work and be sure to support them.
Thanks so much, Evan. Um, so I want to just acknowledge Diane's RCV issue, and basically this is ranked choice voting. And what's going on here is that there are some folks who are upset that Lisa Murkowski won a Senate seat in Alaska because they controlled the primary system before under the old system. And they don't want that to happen in other parts of the country. And as a result, they have gone on a tear against ranked choice voting. So this is really kind of about power and acquiring power and I do want to say, very much related to that, I think we've got three big problems in this country. One is this massive gerrymandering problem. Right now, 8 to 10% of voters elect 82 to 85% of the US House. And that's because of the combination between massive gerrymandering and low turnout primaries here that basically select candidates who are gonna win because of these gerrymandered districts. So that gerrymandering is a real problem that we've gotta address. And any further dismantling of the Voting Rights Act makes that problem even worse. Another challenge we have is there's cultural anxiety, whether it's Germany or the US or Brexit, as a result of we're a large, diverse country here. And we've got to kind of learn to share power. We're becoming more diverse. And if we ignore that, and if we pretend like race and cultural anxiety and these things don't matter, we're just completely missing the boat. And so we've got to recognize that and figure out policy solutions so that we can share power together. And then finally, the challenge we have is we've got this court. This is one of our three branches of government. And it is right now not always acting in a way that is legal and about law. There's a political aspect to it. Part of it is the way that the nomination process works and kind of the outsized role of the Senate in the nomination process. There are a lot of political reasons, but we can't avoid confronting and facing that and using our democratic process to fix that institution.
Well, thank you both so much, and thank you all for joining. I also want to thank Darcy McConnell from Court Accountability, our Chief of Staff, and Alyssa Bowen from True North and Court Accountability. She's my Deputy Executive Director. I want to thank Rift City for its comm support for this webinar. And also, I just want to close on a quote from my hero that I used to open my book because I just don't know what I don't know. I rely on this on a regular basis, and this is from I named True North Research after the North Star, the abolitionist paper of the great Frederick Douglass, and he wrote and spoke with such beautiful eloquence. And one of his quotes that touches me, and I'll just conclude with this for this webinar, is power concedes nothing
Nothing.
without a demand. It never did, and it never will. Find out just what any people will quietly submit to, and you have found out the exact measure of injustice and wrong which will be imposed upon them. And these will continue till they are resisted. And then I conclude with his
Hmm.
words, the limits of tyrants are prescribed by the endurance of those whom they oppress. So with that, we will
Wow.
wrap this webinar and thank you all so much for your time and your grace, and to Evan and Spencer for your brilliance and great hearts. Thank you so much.
Thank
Thanks
you.
for having us.
Thanks.